and the Consumer Protection Act. Although it's a lot of acts that is available. The Consumer Protection Act, I won't say it overrides all the acts, but it is the last act that covers up the consumer. So everything falls back to the Consumer Act. And you will see if we handle a few things here, even in the old laws, will be changed by the Consumer Protection Act. So the National Credit Regulator, let's read this because I put this in. This says the credit market and monitor access to credit and the cost of credit to identify factors that may undermine access to credit, competitiveness, and consumer protection. Receive and investigate complaints and ensure that consumer rights are protected. Enforce the Act and take action against contravening institutions. The National Credit Regulator will monitor credit providers and their compliance with the Act and regulations. And they are quite strict to that. A national consumer tribunal is established to adjudicate in a wide variety of applications and to conduct hearings to complaints. You can go on the ncr.org.za website if you want more information, but I have put the full act for you on the site as well. The total cost of ownership.
Sorry,
yes?
Rena?
Alex? Yes, Alex?
Sorry, I don't know if it's just me, but I think you're breaking up quite a lot, eh? I think you're breaking up quite a lot. I don't know if it's just on my end. I don't know if the others can just speak up and see if it's just me, but you're breaking quite a lot.
I think it's on your end, Alex. From my end, I can hear her perfect.
Okay.
Yeah, what I can hear, there's an echo, so I think there's somebody's sound that's open. Okay, let's hear now. Yes, it's better now. Alex, can you hear me better now? Okay.
I'm just going to move around to see if I can get a better signal in the house or whatever.
Okay. Yeah, sometimes I think our network is also not up to standard anymore.
Okay.
The total cost of ownership. Various vehicles exist for purchases of immovable property. Transfer can be effected to a purchaser in his personal capacity, a natural person, a juristic person, a trust, a company, or close corporation, and the choice depends on the specific requirements of the purchaser. The most important factors to be considered by the purchaser when selecting a suitable registration entity are briefly discussed hereunder. Transfer duty. Two recent amendments to the Transfer Duty Act will have a significant influence on the selection of the mode of acquisition. Prior to 13 December 2002, transfer duty was payable where immovable property, as opposed to the member's interest, shares of beneficial interest in a property owning close corporation, company, or trust, was acquired. Now, I want to stop here for a second. I want you to either make a note, if you are not on your cell phone, I want you to go to your Play Store and you must look for the Uber. Uber, there is the word OOBA, application. I'm going to open it on the computer. I'm going to not share this one. Let's share this one. Can you see the Google site?
Yes, we can.
Okay. You go to uber.co.za on your cell phone, you just go, it opens the app immediately. This is how the logo looks like. But why I want you to use this one is for two reasons. If a client sits with you and asks you, number one, how much can I afford? Or pre-qualify now, or apply for a home loan, then you can do it immediately while you're with them. You can even let they download this, and then they can get themselves qualified or whatever. Now, there's different calculators. The bond calculator, let's go there, the calculators. You get a bond calculator, you get a repayment calculator, you get a transfer cost calculator, extra payments calculator. If it happens that, say for instance, your repayment is just R1,000 and the client decides now he wants to pay 1,500, you can see there what you can save there. Deposit savings calculator, and this how that goes on. So the one that we use the most is your transfer and cost calculator. Now, before we go there, I want to open another one for you here. If you say transfer and bond cost table. Sorry, I had this open before my computer crashed, so I just want, not the calculator, I want the table. Let's go to images. This is the one that I've put up for you. You will hear that they say there's no transfer cost up to a certain amount. In this instance, it's up to 900,000. You will not pay transfer duty. Now, I think confusion comes in, and this is why I would like to, before I go back to the calculator, make it clear for you, is that it is not the full transfer cost that you get exempted for. It's only for the transfer duty. This is the portion that will be paid over to SARS for the transfer duty fees. So up to this, you will see there the amount, total transfer fees is up to 910. It will be 2869. But now all of a sudden, look there how it jumped from 1.5. Now you start paying your transfer fees, transfer duty, sorry. This is the total transfer fees, and this is the transfer duty. So you only get exempted for the duty, not for the full amount. Because this is the money that they have to pay to the deeds office, general disbursements, transfer fees, that is the attorney's fees, and this is the purchase price. Now, left normally is your transfer cost, right is your bond cost. If you purchase a property, say for 700,000, but you put 200,000 down for your bond, then it means you're going to pay 17, this one, plus on this table you will look on 500, you will pay 28,594. Is that clear? Any questions to this table? The price here can vary between 5 to 8% depending on the attorney.
Rina?
Yes.
Just please repeat the last statement where you said if you buy a property for 700,000 but put a deposit for 200,000. I didn't get that.
Okay. This is the purchase price on this side and the registration fees. Okay? So you purchase this property for 700,000. Your registration fees for the 700,000 is going to be 17,494 rand. But you put a deposit down of 200,000. So your bond is not 700, you go to your bond to 500. So your bond cost, your bond registration will then be 28,594. This, the attorney to handle the bond transfer will be appointed by the bank. It's always a different attorney. Your registration attorney gets appointed by the seller. Is it now clear, Kabela?
Yes, it's now clear. So, if I'm understanding you correctly, right? If you take that 700,000 and you apply for a full bond of 700,000, then
Yeah,
your bond registration amount becomes 34,988.
that's 100% right.
Thank you.
Yeah, so this side is your registration, is your purchase price, and this side is your bond cost, your bond price. If it happens that you take a higher bond, normally they do not allow it, but for what reason? Obviously, you will then look on the higher price. So whatever the bond registration is here, you look this side, and this is your purchase price. Now I'm going to back to this Uber calculator. The one reason also after the Consumer Protection Act, remember the Consumer Act is for the clients. In our case, we have to protect ourselves. If it happens that you in person, in the older days, we could there's a formula where you can work out exactly what is the bond and transfer cost that the client is going to pay. But we are not using it anymore for the simple reason, if it happens that you miscalculate the amount, that purchaser can keep you liable for whatever the difference of that calculation is. Now, if it's less, obviously he's not going to fight with you, but if he must pay more, obviously he's going to fight with you. So to prevent that, we do not go into that calculations anymore. We rather use the Uber app. It's better if you use it on their phone and say, type it in, and then you cover yourself up. Say, for instance, the purchase price is 1.5, and your loan amount, let's also make it 100%. And the status, there you can see, is it sectional title or freehold? Let's put a freehold. Is the seller registered for VAT? Obviously, on the freehold, no. Status of the purchase, it's a natural person. And there you can pick company, close corporation, or trust. And you calculate it. And there it comes up. And then you must tell your client, this is plus minus. It depends on the attorney's cost. But normally, I always say about 5,000 Rand or 5%, but the 5,000 Rand can do whatever ups and downs. Your bond registration then will be 35,298 in total. There is it. And there is your transfer cost for the registration. This is the bond registration. This is your transfer registration. And then you can even email the client this thing, or yourself. And then you can even go and check the credit score. So this app gives you a lot of opportunities that you can do here. You can even go in on the calculator, on the repayment calculator, to say that if I want to purchase for 1.5 million, and you're going to pay for 20 years, and the interest rate is going to be 7%, and I'm going to put, say, 100,000 down for a deposit, and you say calculate, it comes up exactly what is your repayment going to be. And this is the total amount that you're going to repay. And this is very nice to see that you purchase for 1.5, you pay 100,000, so it's actually your bond is going to be 1.4, and you are going to pay back at the end of the day 2.605. Any questions? Or is there any other things that you would like to see on this app?
Hi, Rina.
Yes, hi.
It's Connie here.
Yes, Connie.
If you can just go back to that other screen where you were doing where it was calculating the bond registration and so forth. I saw there were other figures that were just below it, and they were different from what was on top there, and I couldn't understand that.
This one.
Yes, this one. Just below the bold, the bigger font, bond registration.
Okay. Let's quickly redo it. 1.5 on this one, and we say the bond. We're going to change a little bit now, and the status, it's a freehold and not registered. And let's say in this instance now it's a company. There you see the difference. The big one, the bold, as you say, this is the total. Now, if you calculate this bond registration cost, including VAT, it's 26,220. Bank initiation fees 6,038.
So that's basically the summation of everything.
Yeah. So this is the total, and this is the total. And there you can see the transfer duty, 18,750. So if we change this now, say to 800,000, 800, and let's say 800. There you see transfer duty, 0.
Okay. All right. One more thing.
Yes.
I think, I'm sorry if I missed it.
No.
In terms of this app, is it something that I can just download on my phone as well?
Yes, you download it on your phone. It's for free. It's so easy to use, and it actually makes life easy for all of us. That's why we are not going into the calculation figures. We rather prefer that you use this app, as I said, also according to the Consumer Protection Act, that you do not give wrong information to the client, because now you can fall back to say, but this is what Uber said. Just make sure that you've got enough money. That's all.
What is it called? What is the app called?
Uber, OOBA.
Oh, double
there
O.
It is, OOBA.
Oh, I
and
thought
it's
that was
free.
Uber. Sorry.
Yeah.
Thank you.
Yeah. But it's nice. You can even, while you're sitting with a client, while you're busy with the OTP, one can let them download this app and they can get themselves pre-qualified like that. And then they will immediately get called by the Uber people, and they can, it's actually a very nice one to have.
So, Rina.
Yes.
I just want to understand the extent of that pre-qualification. Remember, if you do a pre-qualification normally with the bank, right, they will request your 3 months bank statement, FICA documents, and whatever. So for Uber, when they pre-qualify you, they'll call you and you'll provide them with those documents. Or
there's a pre-qualified. That's what I say, a pre-qualified. Ne? There's 2 ways to do a pre-qualification. Is that Uber is connected to the bank system, so their pre-qualification is better than if we actually only do our own TPN report.
Okay.
So we can do a TPN report on the client to see, does it qualify? Because sometimes they do not even know for what can they be listed on the National Credit Bureau. So Uber's got 2 options. Either they do that one, then we can have an answer within 2-3 hours to say, yes, this client looks good. It's not to say they are good, but it looks good. And that helps that we do not just jump in our cars and take the clients out and then, they cannot qualify. And then you get the other pre-qualification, what you talk about. The banks do not like doing it anymore. In certain instances, we turn their arms, but they don't do it as they did in the very big past, where they do actually pre-qualify the client properly with the bank statements, with everything, and then they will say this client can purchase for an X amount. Also, Uber can ask them for those documentation and get them qualified and say, yes, they can purchase for an X amount. The reason why I do like to pre-qualify a client is that, it's, I won't say it's wrong, because we don't do anything wrong, but if you offer that client the assistance and to get them qualified, the intention from the client side is they prefer to stay with you. So you actually purchase yourself a client by pre-qualify the client. because that is a good service that you can offer the client. Any questions to this? You think you will be, you can play around with this, and we can come back to this if you played around and there's questions. It's not a problem. Connie, did you see the transfer cost? Did you come in time for this?
Yes, no, I saw that. I'm covered.
Oh, you did. Okay. Yeah. All right. All right. Then I can go back. All right. So you're happy with the Uber app and the transfer duty table? Since the amendment to the Transfer Duty Act on 13 December 2002, transfer duty is now payable on the transfer of a member's interest, shares, or beneficial interest in a trust as well. Where the purchaser of the interest or shares is a natural person, transfer duty is charged on a sliding scale, while an entity other than a natural person pays transfer duty at a flat rate of 10% of the purchase price. A change in the interpretation of the Act by the receiver of revenue has also curtailed that the purchaser's ability to sign an agreement of sale personally whilst receiving the right to nominate another person or entity as purchaser, usually within a stipulated period from date of last signature. Now, I quickly want to emphasize something here. In the old days, again, I like to refer back. I think you know, or you heard the terminology of a tripartite agreement. Now, what happened in the old days with the tripartite agreement was similar than what we do with a flips property, where you purchase a property, fix it up, and sell it on. In the old days, the party who purchase and sell doesn't pay the transfer duty or the registration fee. So you purchase from the purchaser, the seller, quickly fix it and sell it off before his own transfer goes through, and then it means he doesn't have to pay any cost. Now that was stopped. You can't do it anymore. So each party must pay full transfer fees and or bond fees. Normally there's not really a bond, but there's definitely the transfer fees. But to nominate somebody, it's a different scenario. Say for instance, I saw a nice development land and I know by tomorrow it's going to get sold. Then I go and I sign an OTP with a condition that I've got the right and I'm reserving the right to nominate. So then I come back, I've got a signed agreement with good terms and regulations in it, and then I go say to Alex and say, Alex, are you interested in this property? And then I nominate Alex to be the purchaser, meaning I'm not going to get anything out of it. It is just a third party. Or Alex can give me a power of attorney to sign an agreement on his behalf, but but also then it's not nomination, it's a power of attorney, but a nomination, you don't get anything out of it. If there is a private deal between me and him, it's a private deal, but it's not like buying from this guy, selling it on for a higher price to somebody else. Is that clear? Okay, that purchases. Pardon?
Rina, sorry,
Yes.
just a second. So why would someone go through the trouble of nomination if they're not going to sell that property or that land at a higher price, and they're going to sell it at the cost that's on the OTP?
Well, the thing is to nominate someone else. Let me use another example. Let's say Muma, a property comes on their table and they think they might be interested in buying this property. and they sign an OTP. But tomorrow, another transaction passes the table again that looks better. Then, but the first one is not bad. It's not a no-goer. Then they can ask someone else, are you interested, and then nominate another buyer. Does that make more sense?
Yes, Rena, thank you very much.
Yeah. It is just that the original signee or purchaser doesn't want to carry on and he nominates another buyer. And this happens sometimes quite often. Also, another nomination can be for in case, especially with the new developers, maybe your own or the company that you want the property to go under is not properly registered or maybe doesn't comply yet for the tax purposes or whatever reason. Then you sign the OTP under your personal capacity and you keep this right open to nominate, and then you nominate your own company. So it will be then registered in the name of your company. But remember, then that nomination must happen before you submit for application for funding, because on funding you have to submit under the entity that you're going to purchase.
So Rina, if I can just get clarity after that. So if MUMA transfers the what were the words that you were using there?
The OTP, the offer to purchase.
Yes, the OTP.
Yeah.
Do we have to change the details on the original OTP, or is it a separate document that is signed on the side to say that they're signing over or they're handing over those rights to the next person?
No, we just put an addendum to that contract because the contract stays in place because of the fact of the terms. You have to submit the funding must be in place within, say, 60 or 90 days, and the whole contract stays in place. It is just the purchaser that changes, and that you just do an addendum, and then, say, MUMA said then, MUMA is the clause, that specific clause is keeping the right to nominate now Gert or whoever the new purchaser is to be the new purchaser, and then you give all the details of the new purchaser, and that's done. And then also, obviously, all the SICA documents, ID documents, all the FICA must also then be collected and submitted to the attorneys.
All right. And then the other thing, then does the owner of the property still get involved in the addendum? Does he still need to sign, or it is something that can be handled without him, where you don't need? Because now the other thing could be, if you still go back to the owner of the property, he could think that maybe you're wasting his time, and he says, no, now I don't want to continue with this, because, for an example, with the projects, in terms of the development, a lot of things that is happening is that you find that my project gets approved, but because I'm still struggling and I'm still looking for investors, now that a lot of time passes, and then by the time I find another investor, and then we want to go back to the owner of the land, now he starts saying that, no, you guys have wasted enough time. I'm not going to continue with this. Do you still need him to form part of that addendum, or is it something that you can just continue with between the purchaser and the lawyers?
You can just continue between the purchaser and the lawyers, for the reason is that the owner already signed the original OTP with the clause in that MUMA is reserving the right to nominate another person. So this does not mean that you can cancel the contract. This doesn't give the owner any right to cancel the contract unless the contract has already expired. But you must remember, once you sign the contract and the due diligence, after the due diligence, and you say, no, I'm going to go ahead, this contract is binding. And they cannot just pull out. And I cannot just tell you, listen, I don't want to go ahead. And if an agent is assisting the owner telling you so, whilst your contract is still in place, it means they've got another buyer. I won't fall for that one if they want to force me to cancel a contract.
All right, thanks.
Yeah, because they've already signed that nomination in the contract.
Rina?
Yes.
Just to affirm a bit. So you get a client and they want to sell their house or their land or whatever, right? Then you sign a mandate with them, let's say for 90 days.
Yeah.
What happens if before the 90 days lapses, the client says, hey, you know what, I'm no longer selling? Is there
He can't do so. No, he can't do so. There was a case here in Pretoria North, in fact, where the sellers decided, well, they decide they want to sell because they want to move to the eastern side. The children is in Wonderboom Primary School, and they want to move that side. So before they looked for properties, they put their property in the market, and the property was sold very fast. But then they start looking for properties that side. Then they realize that, gee, we are going to buy for more expensive than what we've sold for. And then they want to cancel that contract. And then the agent turns around and says, sorry, you will pay me my commission because my purchaser was not at default. I was not at default. The bond was approved. All the documentation is on the edge of signature. If you don't sign those documentation, we're going to put a claim in against you. And the lawyers wrote them a letter to say, if you cancel, you're going to be liable for all our costs. At the end of the day, the total cost on the default would have been more than what they will just up the price to pay for a more expensive house.
All right, so in the event that there was no offer to purchase in place, it was just a mandate to sell. In the event that there was no offer to purchase, they can say, no, I'm no longer selling.
Yeah, yes, okay. They can withdraw. Yeah.
Thank you.
As long as it's not on an OTP, they can withdraw, but on a mandate, they can withdraw.
All right, thank you.
Okay, VAT. Purchaser must keep in mind that no transfer duty is payable if the seller is registered as a VAT vendor on date of registration, in which event the seller is liable to pay the VAT, charged 15% to the receiver of revenue. Protection from creditors. This is an important consideration, especially where the purchaser will be trading. And this comes in on buildings, and you must be very careful with this one. Buildings where you purchase, where there is a commercial portion under the blocks of flats, you must make sure, and your contract must be very clear to say that if there's anything outstanding on rates and taxes or any other sureties, that you as a new purchaser will not be covered for, or the seller will still be liable for it. And that is a very important clause to have in your contract if it's a VAT vendor. Administrative cost. Certain registration entities are more costly to administer than others. Capital gains tax and other tax considerations, where capital gains tax, estate duty or other taxes are payable, and what rate depends on the entity selected.
Rina?
Yes.
Sorry, can we just go back a bit? So you're saying that if the seller is a VAT vendor, you must put in clauses that says should there be anything in arrears, they must cover them and everything like that.
Yeah.
So now, what happens in the event is just a normal residential property and the person is in arrears with maybe municipal bills or whatever. Can that clause still be in place? How does it work out?
Okay. Luckily, if it's a municipality, you have to put that clause in. Our contracts has that clause in to say that the new purchaser is not liable for any municipality in arrears, because you know what the municipality is doing? They give you clearance figures, and then 2-3 years down the line, all of a sudden you receive an account of 20, 30 or whatever thousand rand, and you have to pay it, or your electricity being cut, and then it works out that this is an account for 5-6 years ago with the old seller. And that is where the Consumer Protection Act actually jumped in and said, no, that's not going to work that way anymore. And there was court cases to cover it up. They've tested it in court, and the court said no, they stick to the Consumer Act, where the municipality cannot claim from the new purchaser any arrears from the old purchaser. And my opinion is, why will they give a clearance certificate if their system is not updated? I don't know. But I always stick to the clearance figures, and you put that clause in, then you are covered. But what if it's a VAT vendor, meaning there must be commercial, and what if the seller signs surety maybe for any other deposits, maybe he's got like those prepaid systems or whatever, and then you land up with other costs. So whatever contract you sign, if it's a share agreement or a proper OTP, on the commercials, you have to put in there that the new purchaser is not liable for any arrears whatsoever. Doesn't matter for what it is of the seller. And that is also why there is an advert in the Government Gazette if you purchase the shares or if you purchase the company, then they put it in the Government Gazette to cover you as well. Does that answer you, Kabela?
Yes, it does. Thank you, Rina.
Irina, before you
Yes.
just on I just wanna make sure that I'm understanding the VAT one properly. So what it's basically saying is that if the purchaser is buying from a seller who is registered, who's a VAT registered vendor, then there are no transfer fees to be paid.
Yeah. What happened is it's either transfer fees or it's VAT. Either or. You can't pay both.
Oh.
Okay, so if it's a VAT vendor and you are not registered for VAT, then you have to pay VAT. So he will pay that VAT over to SARS. If it happens, and that is now the new thing SARS is doing, is that with our new companies, if it happens that the property, the income, the commercial income of the property is more than 50,000 rand, then you can freely register for that. But SARS sometimes said now that if you are a new VAT vendor, you must still pay the VAT. But then you can claim that VAT back immediately.
All right. I don't understand this last one. I'm sorry. Capital gains tax and other tax considerations. I'm struggling to grasp what it's saying there.
Okay. Capital gains tax is especially when you do a business on the flips properties, where you buy and sell, and it's on your second property, not on the primary property where you stay in. So if you sell the property that you stay in and you buy another property, then you're not going to pay capital gains. Capital gains means you pay tax on the profit what you make on that property.
Oh.
If you do flips where you buy property, fix it up and sell it on, and that's your business, then you will pay capital gains tax on the profit.
Okay.
Okay, not on the whole amount, on the profit. Yeah, so you must keep anything that you do with that property, your estate agent's commission, your registration fees, the fix-up money, whatever cost you spend there, you can claim back, or you put it against the profit, and then you only pay for the profit portion. You pay the capital gains tax. Estate duty or other taxes. Estate duty is on late estates, or attorneys can ask for maybe, I think sequestration has also got a duty on. There is other taxes on property as well that is that they allow that you can deduct.
Thank you.
Okay. Contractual incidents. Now this is under the common law. Now common law means if I want to sign an OTP, I don't have to put in, like for instance, the breach clause. Actually, the breach clause is under the common law. I don't have to put it in there. We put it in for the people to know. But if it's not in there and your contract gets in trouble, when it gets to court, definitely they will refer back to the common law, because on the common law they think that we were supposed to know it. That is actually in simple language what it means is you are supposed to know it. You are supposed to know that you have to apply for a loan. You are supposed to know that you are not allowed to cancel a contract just for no reason. So that's what it is. Contract of sale, a little sentence like Piet Poggenpoel hereby sells Earth 113 Honeydew, Johannesburg, to Jimmy Smith for 100,000, written down and signed by both parties, will constitute a valid and legal binding contract. You only need 4 things in your contract: the names of the purchaser, the seller, the price, and when are you going to pay him? When and how you're going to pay him. That's all. Then it's a binding contract. I've seen an attorney signed an OTP to buy development land on one piece of paper. You know, this old books that writing paper books that you get. We don't buy it anymore, but on one of those he wrote an OTP for a development land, and it was legal and binding. We went twice to court with that same little OTP. A contract of sale is a written document that identifies immovable property, a buyer, a seller, and a purchase price, and clearly states the intention of the parties to transfer ownership is a valid contract of sale. The fact that it is a very short contract of sale that doesn't mention things like occupation dates, mortgage bonds, fixtures, fittings, does not make it invalid. The law that governs contracts for the sale and purchase of immovable property in South Africa is the Alienation of Land Act. The Alienation of Land Act requires that an agreement for the sale of immovable property in South Africa must be in writing and be signed by the parties of the agreement of their authorized representatives. Refer to Learning Unit 2 for the detailed information of the Alienation of Land Act principles. I think Numisa did this one. It was actually very good. The document must contain a description of the parties, the property, and of course the purchase price. Nothing else needs to be discussed in the agreement or recorded in the contract of sale. And please make a note against this one. This is one of the questions in the NQF 4 exams. The relationship between the two parties, meaning everything that is not mentioned in the written contract, is governed by the South African common law. Any questions?
Sorry, no?
Yes.
We can't see the notes on the screen. I don't know if you disabled that.
No, I haven't. Can everybody else see it? You want me to read it?
Yes, we can see it.
You think I must reshare?
There we go. Okay,
But
now
now
I see. Now I can't see.
Yeah, now it's off now. Let me, it's shared it again. Can you see it now?
Not yet.
Yes, we can.
There we go. Okay. Please go back to the one that you said is very important that will come up in the exam.
It's this one. Refer to Learning Unit 2 for the detailed information. It is the document must contain what is a contract. It is a description of the parties, the property, and of course the purchase price. Nothing else needs to be discussed in the agreement or recorded in the contract of sale. It is actually this page is number 18 and number 17. You can also read this. It comes from this contract of sale 1.4.1. The interesting thing about contracts of sale and purchase of immovable property in most areas of the world is that it can contain absolutely any conditions. If the parties agree that a condition that will cause the buyer to pay 20,000 rand more for the property should be in the free state when the curry cup in 2 weeks' time must be included in the contract, they can do so. Yes, anything goes as long as it is legal. And that is why it's so crucial for you to read the contract. If you are not satisfied or if the contract looks too thick for you, rather ask them, give me the contract to read. You've got 100% right to do so. Let I give it to you, read it, or send it through to somebody that can read it so that you can know that, like this one, I will say silly clauses are not in the contract. Because sometimes attorneys on behalf of their clients. Common law. A contract of sale for immovable property in South Africa is usually not just a one-sentence affair. Now, the important terms of the agreement, such as the date of occupation and possession, whether the sale is subject to a suspensive condition requiring the approval of a home loan, exactly what is included in the sale, and descriptions of other rights and responsibilities of the parties are included in most contracts of sale. Anything that is not addressed in the contract of sale is governed by common law. Common law, as I say in simple sentence, is you are supposed to know. The principles of South African common law are well established, but not always clear or even logical to everyone. For this reason, it is always best to address all the aspects that may be involved in the sale of the property in the written contract of sale. These other clauses to the contract of sale are usually where the mystery starts for most South Africans. Legal practitioners draw up most contracts of sale, even those used by real estate agents. Unfortunately, legal speak is not really a popular home language in South Africa, and the familiar words and weird sentence constructions attorneys use in some contracts of sale baffles most normal South Africans. I think most is like 90%. Contract clauses. Each clause in the... Yes.
Sorry, Rina.
Yes.
This common law that we're talking about is law that is what regular and people are supposed to know, not your common law wife or husband, right?
No, not your wife, husband one. But even it's not that the way of marriage. This is common law. It's the, I will say, the umbrella on over all the laws.
Okay.
Okay. Each clause in the contract of sale should state to whom it applies, what has to be done, and by when it should be done. These aspects can be spelled out in names, exact description, and specific dates. But as long as they can be reasonably determined, they are valid. So an occupation clause that states that Jimmy Smith will have the right to occupy Earth 113 Honeydew, Johannesburg on 1st May 2050 is correct, but an occupation clause stating that the buyer will have the right to occupy the property on the first day of the month after the date of transfer of the property in his name is also valid. Another aspect to keep in mind about clauses in a contract of sale is the intended function of every provision. Some clauses simply state what the parties agree. A clause that states that the parties agree that the rope swing under the big oak tree in the backyard is included in the sale is such an agreement clause, but other clauses intend to cancel the sale if a condition is fulfilled. Other clauses may also intend to suspend the contract until specific conditions are fulfilled. Tomorrow evening, I'm going to do a full offer to purchase with you. I'm going to go through the whole offer to purchase. I'm going to take the longest one that I've got that's got all the clauses in so that you can see what you can put in a contract. And I just want to emphasize that you see there's the different conditions that can cancel the sale. Under the clauses suspensive condition, we had a contract the other day and we were looking for the suspensive condition. There was no suspensive condition in, but there is a clause in for a deposit. And you know how dangerous that is, because if it happens that under the common law, actually, you are supposed to get a bond, and if you do not get a bond, you can get all your deposits back with interest. If that suspensive condition, it doesn't say specific suspensive condition, that seller can keep your deposit. So in any contract, please make sure that there is a clause of suspensive condition in that contract. And that clause says specifically that if you do not get finance, whatever monies you pay, you get it back.
Rena?
Yes.
Just to get clarity on one. In a case where maybe I would sign an agreement with a seller to say that I'm willing to buy this property, but I will pay over 12 months. And we find a lawyer where we transfer the money into the, into the trust account.
Yeah.
Now, if I forget to include a clause that says that all interest that are generated from that money that I've been depositing into that trust account will contribute to whatever total amount that I need to pay. If I forget to include that clause, does the trust or the holder of the trust have the right to keep all the interest that have been generated from the deposit?
It's the same, that the attorney's trust account is under more or less the same laws as the estate agent's trust account. What happened if you do not specify what must happen with the interest? Then the interest in the attorney's case will be paid over to their board, whatever the attorney's board is. So they will have to pay it over. So then nobody gets that money will get paid to the board. Even if I do a rental contract, if I do not state exactly where is that money going to, then I must pay that interest over to the estate agent's board. And normally the new trend is from the attorneys is to give you a letter that you sign to say that whatever you pay must be an interest-bearing account, and they can actually open an interest-bearing account on your behalf. Now, how that interest-bearing account works is that you've got your main trust account that is like an umbrella account, and under that a trust account, they open another account. You don't get any cards or nothing for it. It is just like a savings account, a special savings account under your trust account, where they put that exact money in there. And then you must give permission that they do it. And then on that permission, normally it says that also the interest is for your account. So on date of register, whenever that money is due, then they just take that money out of that account, and it's easier to calculate actually the interest, because then as it fluctuate in the bank's in account, you will be covered with that.
Do you have the right to request a statement so that you can see the interest generated and all of those things?
You've got 100% right to ask them, please, can I have a statement of my account?
Okay.
Yeah.
Rina?
Yes, Camilla.
In terms of these contract clauses, because I'm just thinking that this thing can end up being a 100-page document. I once heard, I don't know if we went through it in the class or not, but there was a law on under immovable property that says something like whatever is bolted to the house. Let's say for example, I'm buying a house and the DSTV dish is bolted there, and the day when I'm supposed to move in, I see that the previous owner actually removed it. I have the right to go ask for it, because when I saw the house, that dish was bolted to the house. So now I'm referring to the example that you made here about the swing at the back of the house will be part of the sale and everything like that. So is that law there, or?
Yeah, what I'm going to show, it's not really a law, but it's a law. It's part of the contract law. But yes, what I will do is tomorrow evening when I go through the contract, that's why I first go through this, then I'm going to do the practical on a contract with you to show you how does that clause looks like, what is standard in the clause, and what can be added.
All right.
Okay. But I will definitely handle that one, Cabela. Okay, any other questions? Okay, resolutive, I think now my tongue is dry. Resolutive condition, sorry. It's one of the intents to cancel the contract if a condition is fulfilled. The contract of sale is subject to the resolutive condition that the seller must deliver vacant occupation of the property to the buyer on or before the 1st of May 2050 is an example of such a condition. Any condition that states words to the effect that the contract will be null and void if something hasn't happened by a certain time or something has happened by a certain time is a resolutive condition. I don't know why you want to give occupation 2050, but okay. Suspensive conditions, yes.
So these clauses and whatever, right? Who's the initial party that writes up the clauses? Is it the agent and the seller, or the agent and the buyer, like the first person who draws them up?
Okay, the first person who draws it is the agent with the purchaser.
Okay, with the purchaser.
With the purchaser. You must remember you are going to be a registered estate agent, so you will be part of, or you will join a company. And that company will have their standard documents, the contracts that you use. And normally our contracts is drafted by attorneys.
All right.
Okay. Okay, a suspensive condition is a condition that suspend the contract until the condition is fulfilled. Means in our case it's normally a bond. That's the only condition. But you can also put in any other conditions that you want to be a suspensive condition. Like for instance, if you doesn't submit for bond application within 30 days, you can also then say that is a condition to be suspended. So you can also, I will say, if I can use the word, make up a condition that is suspended as long as both parties agree to that.
Irina, can I just
Yes.
ask, is suspension and cancellation the same thing in this instance?
No.
When you say that you are suspending a contract, is it cancelling a contract, or you're just suspending it for a particular time?
Okay. Say, for instance, let's go back to cancellation. You are now the seller, I'm the buyer. And I purchased, I signed the OTP, we agreed on the price, everything, everybody was happy. 7 days after we've signed the contract, I saw another house and I thought, oh no, I made a mistake. Then I go back to you and I say, I'm going to cancel. I cannot cancel, but if I do cancel, I can be liable for cost, whatever can be happen. Suspensive means that I put in the contract that it's a condition that if I do not get funding within, say, 90 days, then this contract will be null and void. And no party can keep each other liable for any cost, not the agent fees, not nothing, because the bank did not give you the money, so you are not in a position to purchase this property. And that's suspensive. It's a condition that if that action does not happen, this contract will be null and void.
Understood.
Is that now plot and plan? I'm also going to show you tomorrow night.
Patricia's hand is up.
I can't see any person here, believe it or not. There's no one. So chip in, please. That's fine.
Okay. No, I just wanted to also add on the suspensive condition. Also in my layman's language.
Yes.
Is that if I can give a practical example, you want to buy land or property and you are informed that it's been rezoned already for, let's say, Res 3, that the building plans have already been approved and site development plans, such things. So you would put those things as your suspensive conditions to say, until such time these documents are presented, whether in their original form or copy, but with all the required approvals, you are not going to then enforce the contract. So if only when those conditions are met, then the contract will then be concluded. So those you put them to protect yourself, or even if you're buying your normal house, but they told you that they've got an approved building plan, you may put that in your suspensive conditions to say, until such time you present the plans to me, then the contract will not be concluded. And only then you'll be able to conclude the contract. So that's my layman's understanding, and I've had such an experience before.
Yes, Patricia, you're 100% right there. And to be honest with you, on our development lands now, I'm putting in to add on what you said now, is that the seller is liable to pay for the bulk services, because that is one catchy thing where they can catch you on, is on your bulk services. The agent will present to you and say, there's the Res 3 or Res 4, everything looks lucrative, we are just on the 101, it's ready, they like to use that word, it's ready. And when you comes to the point where you must start with your building plans, then you will realize that they haven't paid the bulk services. There's one development here, I tried to sell it, and actually I did have an OTP on it, and guess what? It was approved 2007. Just the bulk service contribution on that property, it's 15 million rand. What if you've purchased that property with the intention it's ready, because they tell you it's ready, all the paperwork is ready, now you want to start and you land up with a municipality bill of 15 million rand and you're not covered in your contract.
That's really terrible, Rina. So yeah, Yeah, terrible. That's what I've learned, that when, especially for these development properties, you have to make sure that all those are put under your suspensive conditions to protect your purchase.
Yes, yes. Now you're 110% correct there. Any other something else to add on?
I think, Patricia, since you have been exposed to all of these things, maybe you must give us a few pointers that we all need to note here, since we are all trying to be developers, so that we make sure that we cover ourselves.
I think what I will do is with Patricia tomorrow evening, we will do an OTP and I will ask her to add on to that OTP. Maybe
That's great. I can do that.
yes,
Thank you.
I think so. We will talk about it and we will add on, and maybe we can do our own OTP and that will cover all of us. Another thing also with your new developers, especially when you decide, this is a small development, I'm going to buy the land and I'm going to sell the units. Not rental, selling. Plot and plan. I don't know who knows what's plot and plan. Do you know plot and plan?
You plot and plan.
It's really like that. Okay, so what happened is that your architect is drawing the building, and each unit must have their own plans. It's not only a site development plan, it's proper plans. And this is when you want to speculate. But then you get the estate agents in and say, come and sell for me from plot and plan. So meaning you've got your site and you've got your building plans, and you sell before you start to build. And that is, in most instances, before proclamation actually. Because remember, that proclamation will be, this will then be either full title or sectional title, but you are not going to use all the monies from the bank. You are going to use most monies from the purchases. Because if, say for instance, it's a full title development, then the full title development you as the seller will get your money for the land on date of registration, and then as the builder goes on, the builder will draw the monies, and if there's any profits left from you, I think you will have the draw at the end of the last draw. That's where you will then get your profits. So that's also another way that you can do it. I'm going to add another one tomorrow evening for you guys. Fractional title. I don't know if you know fractional title. I will tell you about fractional title. It's a very lucrative one as well for developments and especially holiday homes and things like that. Off-plan buyers need 2 contracts. The client should sign 2 sale agreements when buying a freehold home, off-plan or in a plot and plan development. The one contract is to purchase the land, and the other contract is to build the home itself. So it's a building contract and a purchase land contract. Now, what makes this also nice if you buy like this is you pay your transfer cost on the land price, not on the full total packet price, if I can call it that way.
Brina?
Yes.
Are you saying it's best to sell off plan than to build and then sell after?
Yes, because if you sell first, then you will only pay your architect for the plans up front, and you are going to use the purchaser's building contract money to build.
Okay, I think that's clear. So it can reduce even the debt. I think what you said to me says that the debt of the development can even be reduced that way.
It is because you must remember when you first build, then you have to get the bond or where you get the money from, even if it's cash. Remember, cash money to do that is costly because you are losing interest and you're taking a risk. What if, like for instance, this corona thing happens? So it's a risky one. It's better to do it this way, plot and plan, where you sell and you use the purchaser's money to build.
Oh, that's clear. No, thanks, Trina.
Yeah. Any other questions to this? Okay, the second agreement is with the builder. Should cover everything that is discussed and agreed upon with the person or company who is actually building the home. From the building price, the floor plan, the electrical wiring, the plumbing, the paint specifications, the fixtures and fittings, and so on. Off-plan buyers are often not aware of the need for this second agreement, and the law only stipulates that the transfer of land cannot take place without a written contract. Your clients may find themselves in a situation where they have a piece of land but with no agreement for anyone to build a home on it. Now, the purchaser cannot apply for any finance if he doesn't have the two contracts, because say for instance your land price is like 500,000 and your building cost is like 1.5 million, so the total price is 2 million. He cannot just purchase the land for 2 million. He must have the building contract, and remember your builder must be NHRBC registered, and there must be proper quotations as well. Reputable estate agents working for developers or builders will thus always ensure that the sale agreements between buyers and builders are concluded in writing and in detail. Before buying a home of plan or buying a plot and plan home, there are important disadvantages to consider. There may be various risks involved in this. Is how you can safeguard your clients against this. Okay, patent and latent defects. What's the time now? I'm carrying on. No, we still got one. Now, a patent defect and a latent defect. Patent means this is what you can see with your eyes. Latent means this is what you can't see. This is your roof trusses, things like that. In certain instances, the buyer is protected against severe defects discovered after the transfer on a property has gone through. The law will attempt to determine whether the defect is patent or latent, and on these grounds make a ruling as to who is responsible for the cost of repair. Now, there is in the same law, is in the Consumer Protection Act, whereas the purchaser can 2 years after date of registration cancel that contract due to latent defects. But it's not always that easy. Yes, it can be done, but it's not easy. That purchaser must prove to the court that the seller was supposed to know that problem. For in case, as I say, the roof trusses. Maybe for what reason he went into the roof and there's the roof trusses is full of pests. But then the court can also say that he must give the seller an opportunity to fix. So it's not, yes, a contract can be cancelled, but it's not an easy task just to cancel. A patent defect is clearly visible upon inspection, like a crack in a wall or window, and it should be stated in the offer to purchase who will be responsible for fixing or replacing the defect. A latent defect is not so easily picked up on superficial inspection. For example, a faulty geyser, a damped area concealed behind furniture, or fresh paint, or a leaking roof. When you list a property, It's always good to ask the owner, when last did you paint your house? If the house has regularly been painted, you must look clearly, because remember, if you look at a painted wall, if you see where they've put the silicone or this, what is this white stuff, in, it is, it's smooth. It's a very smooth area. So you can actually, if your eyes will pick up where there was cracks that they may be fixed or whatever, and ask them. And what I normally do is, when I take a client through where it's possible, if there's a domestic worker, try to make an opportunity to get into the house where the domestic worker is, because remember, the owners do not tell them to lie, and they can tell you all the details of the property if you picked up that there was something wrong. In terms of the law, the seller is responsible for all latent defects in the property for 3 years, sorry, it's not 2 years, 3 years, from the date of discovery of the defect by the buyer. It is for this reason that the seller would stipulate that the property is for sale as is Voetstoet, but he is still responsible for any deliberately concealed latent flaw, and can only rely on Voetstoet if the defect was unknown to him. However, the burden of proof is on the purchaser if he alleges that the seller knows or ought to have known about the defect. The Consumer Protection Act actually overruled this Voetstoet, in the sense, it's not like the seller can say, oh, but you buy Voetstoet. It's not like that. He will still be liable for the latent flaws if he knows about it.
Rena?
Yes.
Sorry, let me get something clear. You buy a property, the geyser is bust, the seller doesn't tell you anything. You move in, you can use the geyser, and you see that it leaks like hell. What do? You call your insurance, they fix it up. Are you saying that you can go after the seller up to 3 years from the moment you discover that the geyser is bust?
Yes, but what I will do is, I will not immediately call my insurance. I will call the seller and say, listen, dude, this geyser, you were supposed to know it. It's leaking since I moved in. And also, when you move in, it's like a rental property. Make a list of all the faults in the house. You were supposed to know that, because when you moved in, it was leaking, and now it's a week later, and now it burst. So he's liable for it. Will I get my insurance to come out and you will be liable? Then you tell your insurance, but your insurance is not then going to pay. Then the seller must pay. So you tell the seller, you better pay.
But what if you've already fixed the geyser? Can you still go after the seller?
Well, yes, but now then you can only go after the seller for that portion that you paid in your deposit. For if you can't go for the full amount. It's only the actual money that you paid in.
Okay.
Another latent effect that comes out quite often actually is the electricity. How many sellers knows electricians or are electricians themselves, and they issue an electrical certificate, and you move in and you see, oh my word, if I put the stove on, the outside lights are also going on, and whatever is happening. Remember, that person who signs that COC certificate, that electrician, is liable, not the seller. That person is liable. If there's any mistakes on your electricity, if it's not the way it should be by law, you can call that electrician and say to that electrician, listen, you signed this COC certificate, come here, test it, you will see it's wrong. And if there's any mistake, anything wrong on the electrical system, he must fix it, and wherever he's getting his money from, it's his trouble. If he's not fixing it, you can report him at his board. And they are very strict on the electricians.
Rina?
Yes, Kabela.
How does these latent and patent defects work in the event where, let's say, you are buying a plot of farm, and that house hasn't been occupied for the past 5 years. You can even see from the pictures that it's run down, and your hope is that you'll fix the house up, like when you do flips, the house a bit run down, you want to fix it up and probably sell it. Does this still apply or not? Because you can see with your naked eyes the windows are broken. Like, how then now do we deal with this patent and latent defects in that case?
Okay, if you buy for flips, then you as the purchaser knows you're going to buy, let's call it trouble. You buy the trouble, you have to get rid of the trouble before you can sell it. So then I will say your patent defects, that is everything that you see. A latent defect in that instance will be maybe, let's say there's a foundation crack. You didn't know about it, or you couldn't see it because there's carpets, so you couldn't see that the foundation was cracked. So now you pulled out the carpets and you see actually the carpet was holding your foundation together. That is a latent defect.
Rina, would you also consider the connection of water supply to such a building, where you think that maybe there is water or something, and then maybe they closed off the tap because of over the years, then the municipality have closed off the water. Now when you come in and you rectify whatever at the municipality, only to find out that there's actually there's actually no connection. Now you have to spend extra money to do that pipe laying and doing the connection.
That's definitely a latent defect, because the owner was supposed to know that, because he also wouldn't have water. So that is a definite latent defect.
Rina, just one more follow-up, because I'm not. I understand the patent and the latent defects when it comes to a normal, perfect standing house. So there's an event, I got an inheritance from my grandfather or whatever, or I'm an agent, someone comes and says, you know what, this house is in Polokwane, I live in Joburg, I want to sell it as is, I don't want to fix anything on it whatsoever, and I see it's broken, I want to sell it as is with the equivalent price. Even if it's cheap, it's fine, but I just want to sell it as is. Is there something that you can put on the contract that can say, we know this thing is run down, the roof is leaking, we want to sell it as is, and we're not intending to fix it should you find anything?
Yes, Kabalo, there is. We've got actually a list, we call it a fault list, that you can add as an addendum onto the contract. And that is one of the lists that I'm going to handle tomorrow evening with the contract, because the contract that I'm using has got an addendum to this effect.
All right, thank you.
Any other questions? All right. Did I say? Now, a patent defect is clearly visible upon inspection, like a crack in a wall, and it should be stated in the offer to purchase who will responsible for fixing or replacing the defect. A latent defect is not so easily picked up on superficial inspection. For example, a faulty geyser, a damp area concealed behind furniture, or fresh paint, or a leaking roof. In terms of the law, the seller, I did read this, sorry. Okay, a buyer should ask the seller to supply all warranties and documentation relating to repairs and maintenance on the transfer of the property. Depending on the circumstances, the buyer can cancel the contract and or claim repayment of a portion of the purchase price when a latent defect is present. When my son purchased his house here in Nina Park, when they moved in, we discovered this damp on 3 walls. And then we realized when they went out, and I was actually the agent there, to look at the house, there was big cupboards in front of those walls. And I contacted the registration attorney, and I said, listen, please hold back the registration. I first want to get quotations, and I got quotations from 3 different builders to fix those walls, and it came to 27,000 rand. So I've sent it through to the attorney, and I said to the attorney, as a result of the latent defects, this is the cost. My son is prepared to do it, while they are in there, but we want 27,000 rand back from the owner's proceeds to do that. So we're not cancelling the contract. We just claim the latent defect cost. And the owner knows that if she doesn't approve it, we do have the right to cancel. So they approved it. So that is another way of handling latent defects. So what advice would you give to your client in the event where major latent defects become apparent after the bond has been approved and the process has gone through the deeds office? What are the risks in terms of contractual issues? Who's going to take a chance on this too?
Rina, I will try. I think I'm going to advise the client the same way that you did with your son and say, look, we can try and do this, but the seller will have to pay, or we recoup the money from the seller. If he doesn't approve, then we can probably try and cancel the transaction or get the lawyers involved.
Okay. But on this instance, they say it has gone through the deeds office, means that it has already been registered.
I can
Yes.
Since it has gone through to the deeds office, the only advice that I can give to the client is to have a proof. Let's take the proof to the court and explain to maybe to the judge that this is what happened. The client, and I mean, the seller didn't tell me that the roof is leaking or the geyser, there's a problem with the geyser. So I think the best thing is to take it to the court.
Okay. Anyone else that will try this one?
Rina, I would
Yes,
advise
Gisela.
the client to engage the seller, because there was that clause that said, or something that said that there's 3 years grace period for these latent defects. So we can engage the seller first to try and see if the seller will fix. Then if the seller is not willing to fix, then I guess we can follow the rules.
Yes, that's correct. I will also say what I will do is the registration attorney, because he's also part of this transaction actually, is to get the quotations, to see what it comes on and get 2 or 3 quotations, and then go to the attorney so that the attorney can engage with the seller and say, listen, this is the situation. You've got 2 options. Either you pay this so that the purchaser can fix, or you've got the right to go and fix yourself, because that is what the law says, that he has the right to fix himself. If he doesn't want to do that, obviously, then you can go to court. That's what I will maybe advise. I don't know.
Rina, do you go to small claims court?
It depends on how big is the problem. If the problem, I'm not sure that small claims court, is it under 50 or 100,000? Whatever that amount is, the minimum amount, I'll find out what is that minimum amount, and then you can decide which way you want to go.
But Rina,
Yes.
let's say in the event where I've planted a tree there in front of my house, then I sell the house and the tree grows, and eventually the roots start cracking the foundation. Maybe the cracks were there when I sold, but they were latent. I couldn't see them with my naked eye. But as time goes by, the roots grow so big that now they start cracking the whole foundation. will that be considered a latent defect that I must cover as a seller, or now the new owner is liable for that? Because when I moved out, it wasn't as bad as it is now.
No, when you moved out, it was not that bad. Now it turned out bad. I will say it's not actually under the latent effect because it's more under the common law, under the patent effects, because it is normal that a tree root can damage your house. It was not something like a geyser that you were supposed to know uh, that burst. So I don't think you will have a strong case on roots of trees.
Rina, just to make a follow up on that, based on what you just said, a latent defect, is it something that the seller also knows, or it's something that he also did not know? What if he did
It,
not know?
well, if the seller doesn't know, you must remember, you as the purchaser can prove that the seller was supposed to know. So if you can't prove that the seller was supposed to know, then you can't do anything. So a latent defect is something that you cannot see. Nobody can see it. But maybe the seller knows about it. Maybe there's a small thing. Another thing is a swimming pool that leaks.
Mm.
Nobody sees it. Maybe the seller knows he must put water in every day about 5 centimeters because of the leak. Now you move in and you say, no, now my water is going skyrocket. And then you will say, but he was supposed to know it. It's not something that happens just now. He was supposed to know he's putting lots of water in. So then he must come and fix it. Or you get
So,
somebody to fix it.
so in a case where the geyser was not leaking, and then after you have moved in as the purchaser, and then it starts leaking and burst, would that be considered as a latent, or that is something that just happened?
It's actually a geyser is a tricky one, I must admit, because there is maybe it didn't leak while the seller was there. Maybe the house was empty for 2 3 months. Now all of the sudden the purchaser moves in. What you do first thing, you put on the electricity, you put on the geyser because you want a bath and everything. But did you open the taps to get proper water through your pipeline? If you haven't, and that you put the geyser on and you start putting water in, then it makes steams and then the geyser can burst because of that. So it's not because the owner was negligent. So a
So
geyser
you
is
are
a
just
tricky
supposed
one.
to, I'm saying you are just supposed to do a full inspection on your house before you move in, because some of these things might be difficult to prove um, later on when you have moved in. That's what you're saying.
Yes. And also there's two things: the geyser, your sewer system, and your stove is the three things that is difficult to test prior, because your stove, you can put the oven on because now there's no other plates on, or there's no. Did you see what happens sometimes with stoves? If you put the kettle on, it trips.
Mm.
You don't have a kettle there, so that's why it's difficult to test everything prior or on date of when you moved in. If it's a rental property, I always tell my tenant, listen, put everything on. Everything. What you can, all the electricity stuff, put it on. And your geyser, you as the agent, please tell your purchasers, please just open the taps before you put the geyser on. Because it can happen that someone came through the house, they washed their hands, they opened the hot water tap instead of the cold water tap, but because the geyser is off, they didn't realize it. And at the end of the day, maybe that geyser is empty. And what then? When you put it on and you open the taps, you've got trouble.
So Rina, when you are claiming the latent defects from the seller, can you also claim any damages that were caused by the latent defects? For an example, with the issue of the geyser, you find that it bursts and it damages the ceiling and then it falls. Now you have to replace the ceiling and the geyser.
Yeah, yeah. But remember, you can prove that the owner knew about it. That's a major thing.
All right.
Okay, any other questions? I think we came to the end of tonight's slides. Any other questions?
If we can just deal with this one, number 2,
Yes.
the risks
What
in
are
terms
the
of the
risks in
contractual issues, because
contractual
if it's
issues?
already at the deeds office and it has went through there, contractually, basically, there's nothing that can happen besides the issue that you can make a claim against the seller.
The contractual issues is that what I said is that you have to prove that the seller was supposed to know.
No, okay.
Yeah. I think when I'm going through the contract tomorrow evening, this will come out much more clearer, and the type of contracts that we're using covers you up with all this and also covers the sellers both ways. And I must say, there is not really several times that you get this latent defect stuff. If it's a latent defect, it's so small that most purchasers decide, no, they're not going ahead with the transactions. Any other questions? I think it comes now more interesting, isn't it? Don't you think so?
Definitely.
Yes, Rina.
Yeah, no, I think from now on the heavy stuff is gone and we passed that one. So it's going to become more interesting. And also, I'm going to share lots of documentation and contracts with you, and it will be up on the LMS as well. And if you've got any trouble, just WhatsApp me your email address. I'll email it to you as well. It's not a problem.
All right. Just to share a little story, if you don't mind.
Yes.
I've got a friend who was buying a house, and one of the conditions were the seller had a fish pond, and one one of his requirements or terms were that if you are buying my house, then you have to buy the fish in the fish pond as well. And the cost of the fish were about 40 something thousand. And the deal did not go through just because my friend did not want the fish. But is that something that you can say contractually holds weight, that a seller can force somebody to buy fish that he does not want?
No, I will not sign that. I will say that take your fish. Actually, that's very something, and that's why I'm laughing. Because when my son bought this house, there was an enormously big fish pond. And my daughter-in-law said, you know what, it's too dangerous for the kids. And she doesn't want a fish pond. And the same thing, the seller wants also a silly amount for this koi fishes. And my son said, no, you can take your fish. I don't want your fish. And they actually had to come and take the fish out of the pond.
No.
So they cannot force you to buy it. No. Yeah. Any other interesting stories to share? I think I like this.
That's a very funny one.
Yeah. No, yeah, it's quite interesting, but the main thing that you must remember is that the purchaser can prove that the owner was supposed to know. And it's better to act before registration. That's the short and the long of the story. Okay, if there's no more questions or no more inputs, then we can close for tonight, and I see forward for tomorrow evening, because then it's going to be nice practical again. We work through the contracts and bring some ideas forward.
Thank you.
Thank you, and thank you for everyone, and stay safe.
Thank you, Rena.
Okay, thank you. Good evening. Bye-bye.